And it's Ken Kraetzer at the Professional Association for Customer Engagement meeting in Washington, D.C. For CBSI. And I have a chance to talk with an attorney from Columbus, Ohio, Nick Whistler, who gave a very good talk to the gathering today on the regulatory outlook for 2015. And Nick, you talked a lot about some of the technical equipment that practitioners in the field of call centers, contact centers, and marketers, communicators need to work on. Cell phones, automatic dialers were at the top, I think, of your presentation. What are some of the factors with those two elements that marketers and communicators need to be concerned with?
Thank you. When you're calling cell phones, it really comes down to what type of equipment you're using to call the cell phone. So there's different rules depending on whether you're using an automatic telephone dialing system, as that's defined under the statute and the regulations, or whether you're not using that type of equipment, some type of entirely manual process. That determination, though, can be a little bit more problematic and a little bit more difficult than you might imagine, because they look at not just how you're dialing the numbers, but what that equipment is capable of doing. So it could be a situation where you manually dial a telephone number, but that equipment can also auto-dial cell phone numbers, and because of that, it's held to be an ATDS, automatic telephone dialing system, and a whole other set of rules apply. You need to have a proper level of consent depending on what type of call it is. So the other issue that we see a lot of companies struggle with is making sure that they have the proper level of consent. So for a marketing call, that would be written consent, and for a non-marketing call, debt collection, informational type calls, it's a lower level of consent, but you still need some type of consent and making sure that you have procedures in place to get that type of consent.
And one of the points that you emphasize that is key for so many government officials is privacy. We've had numerous data breach incidents with retailers and others. What are some of the factors related to privacy that marketers need to be aware of?
Well, I think just in general, privacy is moving more towards consumer choice. So the regulations, the enforcement, they're really wanting companies to honor customer choices in terms of how they want to be marketed to, what we're doing with their information once we have it, those types of things. So I see the future holding a lot more legislation, a lot more enforcement of existing laws. I think the data breach issues that are really popular right now, you see a lot of headlines about data breaches of big companies. I think it's all going to lead to more regulation and more enforcement in the privacy area.
Absolutely. And as we finish out this year, what are some of the key pieces of legislation, perhaps at either the federal or state level, the marketers need to keep an eye on and maybe contact their representatives about what their positions might be?
At the federal level, there's hasn't been a ton of significant legislation introduced as far as there were some privacy bills a couple years back. Those largely have not been reproduced other than some do not track issues related to marketing of children. At the state level, though, I think there's a lot of legislation. So you've got all 50 states, and you get a situation where one state enacts such a onerous law that it ends up impacting a company that does business in all 50 states, right? I mean, if it's online legislation or some type of legislation that governs inbound, outbound calls, any type of call center activity, you have to kind of apply a lowest common denominator standard. And there are a lot of state laws out there that are really trying to, California being the primary one that's trying to restrict a lot of privacy issues. You see a lot of restrictions on technologies used to reach customers. And I think it's important to make sure that we're really focusing on substantive conduct, right? How a person is acting, good or bad, versus what they're using, the technologies involved. And I think there's a tendency right now to overregulate technology as opposed to conduct. And I think that's something that we need to be cognizant of and push back on if we see some legislation introduced at the state or federal level.
Great points. Now, if you would, just tell us a little bit about your law firm in Columbus.
Sure. So law firm is McMurray, Peterson & Schuster. It was founded by regulators, so people that had worked in the Ohio Attorney General's office, heads of the consumer protection section. So we basically help companies comply with federal and state laws in all kinds of highly regulated industries, everything from car dealerships to contact centers to debt collectors, any company that's engaging in interactions with a customer, we help them comply, and if they run into issues, hopefully help them get out of it as easy as possible.
That's great. Terrific presentation today. Nick Whistler, attorney, gave a presentation at the PACE meeting in Washington, D.C., the Organization Professional Association for Customer Engagement. This is Ken Kraetzer for CBSI in Washington, D.C.